Here's a fact that will shock you. Only 26% of Americans can name the three branches of government. That means nearly 3 out of 4 people do not know how their own country works. And it gets worse. Only 5% of people can answer basic legal questions correctly. 5%! Think about that for a moment. The law touches everything you do. It's in the lease you signed for your apartment, the job contract you accepted last month, the speeding ticket you got on the highway, and the terms and conditions you clicked accept on this morning without reading. Yet most people know almost nothing about how the law actually works. This is not just about passing some test. This is about your money, your freedom, your rights. When you do not understand the law, you become an easy target. Landlords overcharge you because you don't know your lease rights. Employers underpay you because you don't understand labor law. And creditors harass you because you don't realize what protections you have. By the end of this video, you will know more about the law than 95% of people. I will show you exactly how legal systems work, what your rights are, and how to protect yourself. And later, I will reveal the single most important legal tip that could save you thousands of dollars. Stay until the end. Trust me. Let me show you something that disturbed me. A 2019 study found that only 4 out of 10 Americans could pass the citizenship test. This is the same test that immigrants must pass to become citizens. Native-born Americans are failing it. Jeffrey Rosen, the president of the National Constitution Center, said it plainly. He called this a crisis of civic education. And he warned that without constitutional education, the republic will collapse. Those are strong words from someone who studies this every day. 56% of Americans wrongly believe they have a right to a free lawyer for civil matters. They do not. Free lawyers are only provided in criminal cases where you might go to jail. If someone sues you over a car accident, a debt, or a broken contract, you're on your own unless you pay for a lawyer yourself. This ignorance costs people real money every single day. But here's the good news. The law is not as complicated as lawyers want you to believe. The basics can be learned in 1 hour. That is exactly what we are doing right now. So what is the law, really? At its core, the law is just a set of rules that society agrees to follow. These rules do 3 main things. They protect people from harm, they settle disputes fairly, and they punish those who break the rules. Think of law like the rules of a game. Without rules, basketball becomes chaos. Everyone just fights for the ball. Same with society. Without law, the strong take from the weak. Businesses steal your wages, neighbors take your land, and criminals roam free with no consequences. The law gives you power. It says that if someone breaks a promise to you, you can force them to keep it. If someone hurts you, they must pay. If the government tries to take your property, they must give you fair payment first. Here is something beautiful about law in democracies. No one is above it. Not the president, not the richest person, not the most powerful corporation. The rule of law means that everyone follows the same rules. That is what separates fair societies from dictatorships. Now, here's something critical that most people never learn. There are 2 major legal systems in the world. About 80 countries use common law, while about 150 countries use civil law. Knowing which system your country uses changes everything about how you handle legal problems. Civil law systems have written codes that spell out every possible situation. Countries like France, Germany, Spain, Japan, and most of South America use this system. The judge simply looks up the code, finds the matching rule, and applies it to your case. Common law works completely differently. In countries like the United States, England, Canada, India, and Australia, judges look at what other judges decided in similar cases. These past decisions are called precedents. Once a judge decides something, Future judges usually follow that decision. This matters to you because in common law countries, you can win cases by finding old decisions that support your side. Later in this video, I will show you exactly how to research these precedents for free. This is a secret most lawyers do not want you to know. Let me make common law even simpler. Imagine a judge in 1920 decided that a landlord cannot kick out a tenant without 30 days' notice. That decision becomes the rule. Now, in 2025, if your landlord tries to kick you out with only 10 days' notice, you can point to that 1920 decision and win. Harvard Law professor Holger Spamann explains that common law relies on judges using past decisions to guide current cases. This creates a system where the law grows and changes over time through real cases with real people. The beauty of this system is that it adapts. Technology changes, society changes, and through new court cases, the law changes too. The rules for internet privacy, for example, come from judges deciding cases about emails, social media, and data breaches that laws written 100 years ago never imagined. The downside, is that you sometimes need to research many old cases to understand your rights. But do not worry. I will show you free tools to do this research yourself. Keep watching. Now let's talk about civil law systems. If you live in Europe, Asia, South America, or Africa, this is probably your system. In civil law, comprehensive legal codes specify every matter that can come before a court. Think of it like a giant rulebook. When you have a problem about a car purchase gone wrong, you look up the section on sales in the code. When you have a dispute about your rental apartment, you find the housing section. The answer is written right there. This system dates back to Roman times. The Roman Emperor Justinian first compiled legal codes around 600 CE. These codes were rediscovered centuries later and became the foundation for modern civil law systems across the world. In civil law countries, judges have a smaller role. They cannot create new law. They simply apply what the code already says. This makes outcomes more predictable, but sometimes less flexible when new situations arise. Here's something fascinating that Harvard Law School research revealed. One big difference between legal systems is how judges get their jobs. In common law countries, judges are usually appointed after successful legal careers. They spent decades as lawyers first. Civil law countries often appoint judges right after university. These young judges have book knowledge, but less life experience. Professor Spamann made a brilliant point. A common law judge who was a lawyer for 30 years was also probably a homeowner and an employer, but a young civil law judge might only have been a tenant and an employee. He said, "I can't help thinking that has an impact on how you relate to consumer, landlord/tenant, and employment law disputes." Why does this matter to you? Because when you go to court, understanding your judge's background can help you present your case more effectively. We will cover courtroom strategy later in this video. Now let's talk about something every person needs to know: constitutional rights. The Constitution is the supreme law of the land. It trumps all other laws. If any law violates the Constitution, courts can throw that law out. The First Amendment protects 5 freedoms: speech, religion, press, assembly, and petitioning the government. But only 1 in 20 Americans can name all 5. Most people only remember freedom of speech, which 77% can name. Here's something most people get wrong. 53% of Americans think private companies must allow free speech, like Facebook or Twitter. They do not. The First Amendment only protects you from government censorship. Private companies can ban you for any reason. If your employer fires you for something you posted online, that is usually legal. If a store kicks you out for wearing a political shirt, that is usually legal. But if the government arrests you for criticizing politicians, that violates the First Amendment. The Fifth Amendment protects something precious: your property. The government cannot take your private property without paying you fair compensation. This is called eminent domain. Imagine the government wants to build a highway through your house. They can take your property, but they must pay you what it is worth. You cannot stop the taking, but you can fight for a higher price in court. The 14th Amendment adds another layer of protection. It says the government cannot take your life, liberty, or property without due process of law. This means they must give you notice, a hearing, and a fair chance to defend yourself. This protection matters in everyday life. If a city tries to demolish your building for code violations, they cannot just show up with bulldozers. If the IRS wants to seize your bank account, they must follow strict procedures. Know your rights and enforce them. You've seen it in 100 movies. You have the right to remain silent. But here's what the movies don't tell you. Research shows that between 80 and 95% of suspects waive their Miranda rights. They start talking and hurt their cases. A study estimated that about 300,000 detainees annually fail to recall even 50% of their Miranda warnings. And the study only tested people in non-stressful situations. Imagine how much worse it is when you're scared, confused, and sitting in an interrogation room. Research found that over 97% of people do not know that their rights continue throughout questioning. Here's the secret. You can invoke your right to silence or a lawyer at any point. Even if you started talking, you can stop at any time. Let me be crystal clear. If police ever question you about a crime, say these words: "I want a lawyer." Then say nothing else. Not, "I didn't do it." Not, "Can I explain?" Nothing. Silence cannot be used against you in court, but your words can. Contracts might be the most important legal concept for daily life. A contract is simply an agreement that the law will enforce. When both sides promise something, and those promises have value, you have a contract. Every time you buy coffee, that's a contract. When you click "I agree" on an app, that's a contract. When you shake hands on a job, that can be a contract. Even a text message promising to pay someone back can be a contract. There are 5 elements every contract needs to be enforceable. First, an offer. Second, acceptance of that offer. Third, consideration, which means both sides give something of value. Fourth, capacity, meaning both sides are adults of sound mind. Fifth, legality. The contract cannot be for illegal purposes. Here's the powerful part. If someone breaks a contract with you, the law forces them to fix it. They might have to pay you money. In rare cases, a judge can order them to actually do what they promised. Contracts give your agreements teeth. Here's something that shocks most people. Verbal contracts are often legally enforceable. You do not always need a written document. If you and someone else agree on terms, shake hands, and both provide value, that can be binding. In the famous case of Lucy versus Zemmer, a court upheld a contract written on a restaurant napkin. Why? Because both parties showed they meant it seriously, and value was exchanged. The form did not matter, the intent did. However, certain contracts must be in writing. The Statute of Frauds requires written contracts for real estate, agreements lasting over a year, and contracts above certain dollar amounts. If you are making a big deal, get it in writing. My advice? Even for small agreements, send a follow-up text or email summarizing what you agreed to. Just confirming you'll paint my fence for $500 by Friday. Now you have proof if things go wrong. Not every promise becomes an enforceable contract. Several things can make a contract void or unenforceable. Knowing these can save you from bad deals. Minors generally cannot enter binding contracts. Anyone under 18 can usually walk away from agreements, except for necessities like food, housing, or medical care. This is why car dealers want your parents to co-sign when you're young. Contracts signed under intoxication may be challenged. If someone was too drunk to understand what they were signing, they might escape the deal. People with mental incapacity also cannot form valid contracts. And here's a big one. Contracts for illegal purposes are automatically unenforceable. If someone promises to pay you for doing something illegal, you cannot sue them for that payment. The court will not help enforce an illegal agreement. Property law is another area everyone needs to understand. When you own property, you actually hold a bundle of rights. Think of ownership like holding a bundle of sticks. Each stick represents a different right. The 5 core property rights are possession, control, exclusion, enjoyment, and disposition. Possession means you can occupy it. Control means you decide how to use it. Exclusion means you decide who can enter. Enjoyment means you can use it freely. Disposition means you can sell or give it away. Here's something most homeowners do not realize. You can own property without possessing it, and possess property without owning it. A landlord owns the apartment, but the tenant possesses it during the lease. Some rights can be separated from the property entirely. Mineral rights, water rights, and air rights can be bought and sold separately from land. You could own a house but not own the oil underneath it. Always check what rights you're actually buying. Many people confuse criminal law and civil law. They are completely different. Criminal law is when the government prosecutes someone for breaking society's rules. Civil law is when private people or companies sue each other for wrongs. If you steal from a store, that's criminal. The government charges you. You could go to jail. But if you break a contract with that store, that's civil. The store sues you. You might pay money, but you will not go to prison. The consequences are very different. In criminal cases, you can lose your freedom. That is why you have the right to a free lawyer if you cannot afford one in criminal cases. In civil cases, you only risk money. No free lawyer is provided. The standard of proof differs too. Criminal cases require beyond reasonable doubt, near certainty. Civil cases only require preponderance of evidence, basically more likely than not. That is why someone can be found not guilty of murder, but still lose a wrongful death lawsuit. Courts are organized in a hierarchy, like levels in a building. At the bottom are trial courts. This is where cases start. Evidence is presented, witnesses testify, and a judge or jury makes the first decision. Above trial courts are appeals courts. If you lose at trial, you can appeal. Appeals courts do not retry the case. They check if the trial court made legal errors. Did the judge misapply the law? Was evidence wrongly excluded? That is what they review. At the top sits the Supreme Court. Their decisions become the final word on constitutional questions. When the Supreme Court rules, that decision binds all lower courts. Here's something most people do not know. Over 71% of Americans correctly understand that a 5-4 Supreme Court ruling is still binding law. Even by just one vote, the decision is final and must be followed. Here's a legal secret that can save you thousands of dollars. Small claims court exists specifically for regular people to sue without hiring a lawyer. The court simplifies the legal process through informal trials where judges actively help. If your landlord refuses to return your deposit, take them to small claims court. If a contractor did terrible work, small claims court. If someone owes you money and will not pay, small claims court. Dollar limits vary by state, usually between $5,000 and $25,000. Research showed a 100% victory rate for people who received some pre-trial help. That means if you prepare properly, your chances are excellent. Many court websites offer free guides, forms, and even phone help. Do not be intimidated. Small claims judges expect non-lawyers. They will ask you questions to understand your case. Bring all your evidence: receipts, photos, contracts, texts, emails. The more documented proof you have, the better your odds. Here's something important about real-world law. About 95% of legal cases settle before trial. Going to court is expensive, slow, and risky. Smart people often settle. Studies show that people with lawyers receive settlement amounts nearly 3 times higher than those without. And 91% of people with experienced attorneys receive payouts versus only 51% of those without representation. Does this mean you always need a lawyer? Not necessarily. But it means you should know your case's value before accepting any offer. Research similar cases. And here's a big tip. 70% of people who held out for better deals received settlements $30,700 higher than those who accepted first offers. Never accept the first settlement offer in an important case. Insurance companies and opponents start low. They expect you to negotiate. Counteroffer. And if they will not budge, then consider whether court is worth it. Tort law handles wrongs between people that are not based on contracts. Torts include personal injury, property damage, and harm caused by negligence or intentional acts. If someone runs a red light and hits your car, that's a tort. If a store's wet floor causes you to slip and break your arm, that's a tort. If someone spreads lies that damage your reputation, that's a tort. No contract needed. The law still gives you a remedy. Most tort cases involve negligence. To win a negligence case, you must prove 4 things. First, the other person owed you a duty of care. Second, they breached that duty. Third, their breach caused your harm. Fourth, you suffered actual damages. Research shows that in premises liability cases, plaintiffs win about 39% of the time at trial. In product liability cases, plaintiffs win 38%. These might seem low, but remember, most strong cases settle before trial. Let's talk about when you actually need a lawyer versus when you can handle things yourself. Research shows that at any given time, 100 million Americans have legal issues, but only 16% seek legal help. Many people do not even recognize they have legal problems. They think owing back rent is just a money problem, not realizing the landlord might have violated housing codes. They accept unfair treatment at work, not knowing employment laws protect them. Here's my rule. You can often handle small claims cases, simple contract disputes, traffic tickets, minor landlord issues, and uncontested legal matters. You need a lawyer for criminal charges, serious injuries, complex business deals, divorces with children or property, and any case where the other side has lawyers. Free legal aid exists in many places. Studies show legal aid returns $3 to $13 for every dollar invested through better outcomes for clients. Search for Legal Aid plus your city. Many lawyers also offer free consultations. Here's something that could ruin your case if you do not know it. Every legal claim has a deadline. Miss it, and you lose your right to sue forever. These deadlines are called statutes of limitations. For personal injury, you typically have 2 to 3 years depending on your state. For contract disputes, usually 4 to 6 years. For property damage, often 3 to 5 years. These vary by state and case type, so look up your deadline immediately. The clock usually starts when the harm occurs or when you discover it. If you find out years later that a doctor made an error, the clock might start from your discovery date. But courts are strict about this. Do not gamble. If you think you might have a legal case, act now. At minimum, consult a lawyer to understand your deadline. Many people lose valid cases simply because they waited too long. Do not let that happen to you. Let me tell you the truth about winning legal cases. Evidence wins. Not how loud you argue, not who seems more honest. Evidence. Save every text message, email, and letter related to any dispute. Take photos and videos of damages, conditions, and interactions. Keep receipts for everything you spend. Write down what people say with dates and times. Get witnesses to write statements while memories are fresh. Judges and juries can only consider what they can see and hear. Your word against theirs is weak. Your word plus text messages, photos, and witnesses is strong. Start a folder, physical or digital, for any situation that might become legal. Landlord problems? Folder. Work conflicts? Folder. Car accident? Folder. You may never need it, but if you do, you will be glad you prepared. One big barrier to legal knowledge is language. Studies show legalese is a major obstacle preventing people from accessing justice. Lawyers use complicated words when simple ones would work. Let me translate some common terms. Plaintiff is the person who sues. Defendant is the person being sued. Liability means legal responsibility. Damages means the money you can recover. Breach means breaking a promise or law. Due diligence means doing proper research. Consideration means value exchanged in a contract. Jurisdiction means which court has power over the case. Precedent means past decisions that guide future cases. Statute means a written law passed by legislators. Do not let fancy words intimidate you. When you read a legal document and do not understand something, stop. Look it up. Ask questions. The internet has free legal dictionaries. Knowledge is power, and understanding the words is step one. Most people sign contracts without reading them. Studies show that unenforceable terms in contracts cause people to take actions or bear costs they shouldn't. Companies count on you not reading. Here's what to always check in any contract. First, what are you promising to do? Second, what is they promising to do? Third, how long does this last? Fourth, how can either party end it? Fifth, what happens if someone breaks the agreement? Watch for sneaky terms, automatic renewals that trap you, arbitration clauses that prevent lawsuits, penalty fees buried in fine print, waivers of rights you did not realize you were giving up. You have power when signing contracts. Cross out terms you do not like. Write in changes. Initial them. The other side can refuse, but they might accept. Many phone and cable contracts have been modified by customers who simply asked. If you rent your home, landlord-tenant law affects your daily life. Tenants have rights to a habitable living space and fair rental terms. Your landlord cannot simply ignore problems. Most states require landlords to maintain certain standards. Working heat in winter, hot water, no major leaks or pest infestations, functioning locks and basic safety. If your landlord refuses repairs, you may have legal options including withholding rent or breaking your lease. Security deposits are heavily regulated. Most states require landlords to return your deposit within a set time, often 14 to 30 days. They must provide an itemized list of deductions. If they fail, you can sue for your money plus penalties. Always document the apartment condition when you move in and out. Take photos and videos. Get the landlord's written confirmation. This protects you from false damage claims later. Every worker has legal protections. Employment laws cover wages, safety, discrimination, and more. Knowing these can prevent your employer from taking advantage of you. Minimum wage laws set floor levels for pay. Overtime rules require extra pay for hours over 40 per week in many jobs. Your employer cannot simply ignore these because you agreed to lower pay. These laws override contracts. Discrimination based on race, religion, sex, age, disability, and other categories is illegal. If you are fired or treated differently because of protected characteristics, you may have a lawsuit. Document everything at work that seems unfair. Keep copies of your performance reviews. Save emails that show discrimination or retaliation. Write down verbal comments with dates and witnesses. If you ever need to sue, this evidence is gold. Intellectual property, or IP, protects creations of the mind. Copyrights protect creative works. Patents protect inventions. Trademarks protect brand names and logos. When you write something, draw something, or create music, you automatically own the copyright. You do not need to register, though registration gives you more legal options. This means others cannot copy your work without permission. But here's what many people miss. When you create something as an employee, your employer usually owns it. That app you built at your job? Your company's property. Those marketing materials you designed? Same thing. Check your employment contract. Understanding IP can make you money. If you create valuable content, license it. If you invent something useful, consider a patent. And always check that you're not accidentally infringing someone else's IP in your projects. Laws exist specifically to protect you as a consumer. Consumer protection laws prevent businesses from using unfair or deceptive practices. If a product is dangerous, companies can be forced to recall it and refund you. If advertising is misleading, you may have grounds to sue. If debt collectors harass you, federal laws limit their behavior. If your data is stolen due to company negligence, you may have claims. Many products come with "if not written." Products must be fit for their ordinary purpose. A refrigerator must keep food cold. Clothes must withstand normal washing. If products fail basic expectations quickly, you can demand refunds or replacements. Always keep receipts, packaging, and warranty information. Check credit card protections. Many cards offer extended warranties and dispute rights. And remember, complaining loudly on social media sometimes works faster than legal action. If you owe money, you still have rights. Debt collectors must follow strict rules about how they contact you. Under federal law, collectors cannot call at unreasonable hours. They cannot threaten you. They cannot lie about what you owe. They cannot contact you at work if your employer disapproves. They must stop calling if you send written notice. Collectors must verify debts if you dispute them. Send a written letter within 30 days of first contact asking for verification. They must prove you owe the money before continuing collection. Here's a secret. Old debts have statutes of limitations too. After a certain number of years, collectors cannot sue you for them. They might still try to collect, but they cannot use courts. Research your state's limits. Family law covers some of life's most emotional issues. Marriage, divorce, custody, and support are all governed by specific legal rules. Marriage creates legal obligations. Spouses owe each other support. Property acquired during marriage is often jointly owned. Debts may become shared. Understanding these rules before marriage can prevent painful surprises later. Divorce requires either agreement between spouses or court decisions on disputed issues. Joint tenancy gives equal shares to co-owners with survivorship rights, while tenancy in common allows unequal shares. How you hold property affects what happens after death or divorce. If children are involved, their interests come first legally. Courts decide custody based on children's best interests, not what parents want. Child support is calculated by formulas in most states. Understanding these systems helps you protect both yourself and your children. Everyone needs a will. Without one, the state decides who gets your property. If you have no will, your assets pass to heirs according to state law, which might not match your wishes. A basic will names who gets your property, who raises your minor children if you die, and who handles your affairs. It does not need to be complicated or expensive. Many states accept handwritten wills. Simple templates exist online. Beyond wills, consider other documents. A power of attorney lets someone handle your affairs if you cannot. A healthcare directive tells doctors your wishes if you cannot speak. These protect you while alive. Do not wait. Accidents and illness strike without warning. Spend 1 hour creating basic documents. Update them when major life changes happen. Marriage, divorce, children, major assets. Your family will thank you. How you interact with police can dramatically affect your rights. Most people do not fully understand their Miranda protections. Let me explain exactly what to do. Police are only required to read Miranda rights when you are in custody and being questioned. A traffic stop is not custody, so they can ask questions without warnings, but you can still refuse to answer beyond basic identification. Never consent to searches. Police may ask to search your car, bag, or home. You can say no. If they search anyway without consent or warrant, any evidence may be thrown out later. Be polite, but be firm. I do not consent to searches. If arrested, stay calm. Do not resist, even if the arrest is unfair. Say clearly, I am invoking my right to remain silent. I want a lawyer. Then, say nothing else. Not explanations, Not apologies, not small talk. Nothing. Your silence cannot hurt you. Your words can. Traffic law affects almost everyone daily. Understanding it can save you money, points, and even your license. Speeding tickets are not just annoyances. They add points to your license. Too many points can raise insurance rates or suspend your license entirely. Sometimes fighting a ticket makes sense financially, even if you're guilty. Here's a little-known fact. You can often request the officer's notes and radar calibration records. If equipment was not properly maintained or the officer's records are sloppy, cases get dismissed. Check your court's procedures for making these requests. Many jurisdictions offer traffic school to erase points. Some allow online completion. This small investment of time can prevent insurance increases that cost far more than the class. Always ask about this option. How you present yourself in court can influence your outcome. Judges notice everything: your clothes, your tone, your preparation. Dress professionally. You do not need a suit, but clean, neat clothing shows respect. No hats, shorts, or flip-flops. First impressions matter, especially to judges who see hundreds of cases. Address the judge as Your Honor. Wait your turn to speak, never interrupt. Stand when speaking unless told otherwise. These small courtesies show you take the process seriously. Organize your materials before arriving. Have your documents in order. Practice what you want to say. Time is limited, so make your key points clearly and quickly. Rambling loses judges' attention. Courts are not the only way to resolve disputes. Mediation and arbitration offer alternatives that are often faster and cheaper. In mediation, a neutral third party helps you and the other side reach agreement. The mediator does not decide. They just facilitate discussion. Either side can walk away. But when it works, mediation resolves disputes quickly without court stress. Arbitration is more formal. An arbitrator hears both sides and makes a decision. Many contracts require arbitration instead of lawsuits. Check your agreements. You may have already agreed to arbitrate without realizing it. Be careful with arbitration clauses in contracts. They often favor the company that wrote them. Arbitrators chosen by companies may lean toward those companies. If you see mandatory arbitration in a contract, consider negotiating it out. The internet has transformed access to legal information. Researching legal issues online is now possible for everyone. Free resources include Cornell Law School's Legal Information Institute, covers federal law; Justia and Find Law, searchable databases of cases and statutes; your state's official court website, forms, rules, and guides; local bar associations, often have free legal help hotlines. You can even research case precedents yourself. Search for cases similar to yours. See how courts ruled. Find the legal standards they applied. This helps you prepare arguments or decide if your case is worth pursuing. However, legal websites give information, not advice. Every case has unique facts. What worked for someone else might not work for you. Use online resources to educate yourself, then consider whether you need professional help. Let me give you a concrete checklist of rights everyone should know. First Amendment: freedom of speech, religion, press, assembly, and petition, against government restriction only. Fourth Amendment: protection against unreasonable searches and seizures. Fifth Amendment: right to remain silent, right to due process, protection against double jeopardy. Sixth Amendment: right to a lawyer in criminal cases, right to a speedy trial. Eighth Amendment: no cruel or unusual punishment, no excessive bail. 14th Amendment: equal protection under law, due process from state governments. These rights have limits. Free speech does not cover threats, fraud, or incitement. Search protections have exceptions for emergencies. Know both your rights and their boundaries. The best legal strategy is avoiding problems in the first place. Prevention costs far less than litigation. Get agreements in writing. Document everything important. Read before you sign. Keep records organized. Follow through on your promises. Communicate clearly when problems arise. Most disputes escalate from small misunderstandings. A quick conversation often prevents lawsuits. Apologize when wrong. Propose solutions. Show goodwill. Many people just want acknowledgement and fairness. Build relationships with potential legal helpers before you need them. Find a lawyer you trust for occasional questions. Know where free legal resources exist in your community. Preparation prevents panic. Insurance is actually legal protection in disguise. When you buy liability coverage, you're buying a legal defense team. Car insurance covers your legal defense if you're sued after an accident. Home insurance covers lawsuits if someone is hurt on your property. Business insurance protects against customer claims. The insurance company provides lawyers and pays judgments. Review your coverage annually. Understand what is and is not covered. Increase limits if your assets have grown. The cost difference for higher coverage is often small compared to the protection gained. Document everything for insurance claims. Take photos immediately after incidents. Get witness information. Report promptly. Cooperate with adjusters. But also, know your policy's limits so you know when to consult independent lawyers. The Statute of Frauds is a law that requires certain contracts to be in writing. Real estate contracts, contracts lasting over 1 year, and contracts above certain values must be written. The purpose is preventing fraud through fake verbal claims. Imagine someone claiming you verbally agreed to sell your house. Without writing requirements, they might succeed with lies. Today, electronic signatures have the same legal weight as handwritten ones. Emails, texts, and digital signatures can all satisfy writing requirements if they meet authentication standards. When in doubt, put it in writing. A simple email confirming terms creates a written record. This protects both parties from later disputes about what was agreed. Legal fees confuse and scare many people. Let me demystify them. Hourly rates are most common. Lawyers charge per hour of work, typically $150 to $500 depending on location and experience. This adds up fast. A simple case might cost thousands. Contingency fees are used in injury cases. The lawyer takes a percentage, usually 33 to 40%, only if you win. No win, no fee. This makes legal help accessible but reduces your recovery if you win. Flat fees work for predictable tasks. Wills, simple contracts, and routine filings often have set prices. Ask for flat fee quotes to avoid billing surprises. Legal fees are often negotiable. Ask about payment plans. Request fee caps. Shop multiple lawyers. And always get fee agreements in writing before work begins. Legal help exists for those who cannot afford it. Legal aid programs serve millions of people with civil legal issues. Law school clinics offer free services supervised by professors. Legal aid societies help with housing, family, and benefits cases. Pro bono programs match volunteer lawyers with qualifying clients. Court self-help centers assist with forms and procedures. To qualify, you usually must meet income limits. But even if you do not qualify, many lawyers offer reduced rates on sliding scales. Ask. Search online for legal aid in your area. Call your local bar association's referral service. Many offer free or low-cost initial consultations. Do not let money prevent you from getting help you need. Bankruptcy is not shameful. It is a legal tool for a fresh start. Federal bankruptcy law allows individuals and businesses to address overwhelming debt. Chapter 7 bankruptcy liquidates assets to pay debts, then discharges what remains. You lose some property, but emerge debt-free. Chapter 13 creates payment plans over 3 to 5 years while you keep your assets. Some debts cannot be discharged. Student loans usually survive bankruptcy. Recent taxes survive. Child support and alimony survive. Criminal fines survive. Know these limits before filing. Bankruptcy stays on your credit report for 7 to 10 years, but rebuilding credit is possible. And sometimes, the fresh start outweighs the credit damage. Consult a bankruptcy attorney to evaluate your specific situation. Lost your case? You may have options. Appeals allow higher courts to review lower court decisions for errors. Plaintiffs appeal about 5% of cases they win, but 15% of cases they lose. Defendants appeal 12% of losses and only 2% of wins. Losing parties appeal more often, which makes sense. but appeals have strict deadlines and rules. You typically must file notice within 30 days. You can only argue legal errors, not just disagreement with the outcome. New evidence is usually not allowed. Appeals are expensive and often unsuccessful. Most trial decisions are upheld. Before appealing, honestly assess whether the trial court made clear legal errors or whether you simply dislike the result. If you're ever injured or suffer losses, documentation wins cases. Photograph injuries immediately and over time as they heal. Keep all medical records and bills. Save receipts for every expense caused by the incident. Document lost wages with employer statements. Keep a daily diary of pain, limitations, and emotional impacts. Studies show compensation correlates strongly with evidence quality. Vague claims get small awards. Documented claims with photos, records, and receipts get fair compensation. Even if you're not sure you'll pursue legal action, document everything after any incident. You can always decide not to sue, but you cannot go back in time to gather evidence you failed to collect. Remember earlier I promised to show you how to research legal precedents? Here's the secret most lawyers do not want you to know. Free databases like Google Scholar, Justia, and FindLaw let you search court cases. Type in keywords related to your issue. Look for cases in your state. Read how judges decided similar situations. The key is finding cases with similar facts to yours. If a judge ruled for the tenant in a case just like yours, you can cite that case. Bring it to your hearing. Show the judge that established law supports your position. This research gives you power. You can evaluate whether your case is strong before investing time and money. You can prepare better arguments, and you show judges you take the legal process seriously. Most people accept contracts as is. Big mistake. Many contract terms are negotiable. Read the entire agreement before signing anything. Identify terms that concern you. Ask questions about anything unclear. Propose changes to terms you dislike. Cross out provisions you do not accept. Initial the changes. The other side must either accept, reject, or negotiate. Many businesses accept reasonable modifications, especially if losing your business is the alternative. You have more power than you think. Employees can negotiate employment terms. Tenants can negotiate lease provisions. Customers can negotiate service contracts. The worst outcome is they say no, and you're no worse off than before you asked. Courts have rules about what evidence they will consider. Understanding these helps you prepare winning cases. Hearsay is generally not allowed. You cannot testify about what someone else said to prove the truth of their statement. If you want to prove Bob threatened you, Bob must testify, or you need recordings. Your friend saying, "Bob told me he threatened you," is hearsay. Documents must be authenticated. You must prove documents are what they claim to be. Bring originals when possible. Have witnesses who can confirm document origins. For electronic records, print with metadata showing dates and sources. Direct evidence is strongest. Contracts you signed, photos you took, receipts you received. Circumstantial evidence, facts suggesting something, is weaker but still valuable when combined with other proof. If you need to write legal letters or court documents, follow these principles. Be clear and concise. State facts without emotion. Use simple sentences. Avoid jargon unless legally necessary. Organize points logically with one issue per paragraph. Always include the basics: date of writing, names of parties, reference numbers or case numbers. Clear statement of what you want. Deadline for response. Keep copies of everything you send. Send important documents by certified mail with return receipt. This creates proof of delivery. For emails, request read receipts. In today's world, your digital life has legal implications. Understanding digital rights matters. Terms of service for websites and apps are contracts. When you click "I agree," you're bound. Many include provisions about data use, dispute resolution, and content ownership. Read them for services you use heavily. Privacy rights online are limited but growing. Many jurisdictions now require companies to disclose data collection and allow deletion requests. Check if laws like GDPR or CCPA apply to you. Protect yourself digitally. Use strong, unique passwords. Enable two-factor authentication. Be careful what you share publicly. It can be used against you legally. Screenshot and save important online transactions. Defamation law protects your reputation. If someone makes false statements that damage you, they may be liable. There are two types. Libel is written defamation. Slander is spoken defamation. To win, you must prove the statement was false, it was communicated to others, it damaged you, and the speaker was at least negligent. Truth is always a defense. If the statement is true, it cannot be defamation, no matter how much it hurts you. Opinions are also protected. I think he's dishonest is different from he stole money. Public figures face a higher bar. They must prove the speaker acted with actual malice, knowing the statement was false, or recklessly disregarding truth. This protects criticism of politicians and celebrities. Understanding self-defense law could save your life and keep you out of prison. Generally, you can use reasonable force to defend yourself from imminent physical harm. The force must be proportional to the threat. You cannot shoot someone who shoves you. Duty to retreat varies by state. Some states require you to flee, if safely possible, before using force. Stand your ground states do not require retreat. Know your state's rules. Your home often has different rules. Castle doctrine in many states allows greater force to defend your home, but rules about intruders versus invited guests who become threats vary. When in doubt, retreat if safely possible. Fraud is lying to take someone's money or property. It requires a false statement, knowledge it was false, intent to deceive, reasonable reliance by the victim, and actual damage. If someone lies about a car's history to sell it, fraud. If a contractor quotes one price but charges more without explanation, potential fraud. If a business makes false advertising claims, potential fraud. Fraud can be both civil and criminal. Victims can sue for damages. Prosecutors can charge crimes. The same conduct might result in both. Protect yourself from fraud. Get claims in writing. Verify important facts independently. If a deal seems too good to be true, it probably is. Trust your instincts. Neighbor conflicts are common and often legally resolvable without court. Property boundary disputes are governed by deeds and surveys. If you disagree about where your property ends, get a professional survey. The deed's legal description controls. Nuisances include noise, odors, light pollution, and other interferences with your property enjoyment. Local ordinances often regulate these specifically. Check your city's codes before complaining or before starting activities that might annoy neighbors. Try talking first. Many neighbors do not realize they're causing problems. A friendly conversation often works better than legal letters. But if talking fails, document issues and explore mediation before suing. Zoning laws control what you can do with your property. These local laws often restrict use and development. Residential zones limit commercial activity. Building codes require permits for construction. Historical districts have appearance restrictions. Environmental rules protect water and wildlife. Before buying property, research zoning. That dream of running a business from home might violate local rules. That planned addition might require expensive permits. Know before you buy. Variances and permits allow exceptions. If zoning prevents your plans, apply for a variance. Attend zoning board meetings to make your case. Success is not guaranteed, but people win variances regularly. The best time to prepare for disputes is before they happen. When starting relationships, business, employment, rental, discuss how you'll handle disagreements. Include dispute resolution clauses in contracts. Agree on mediation before arbitration, before court. Keep organized records from day one. File contracts where you can find them. Save important communications. Note key dates and deadlines. Document any problems as they arise. Build your legal support network now. Know a lawyer you can call for quick questions. Understand where local legal aid exists. Bookmark useful legal research sites. Preparation prevents panic. Beyond laws, regulations affect daily life. Government agencies create rules that carry legal force. The IRS regulates taxes. OSHA regulates workplace safety. EPA regulates environmental impact. FDA regulates food and drugs. FTC regulates business practices. Ignorance is not a defense. If regulations apply to you, you must follow them. Penalties for violations can include fines, license revocations, and even criminal charges. Research regulations for your situation. Starting a business? Check licensing requirements. Hiring employees? Know labor regulations. Working with hazardous materials? Understand safety rules. Free agency guidance often exists online. Let's create your personal legal action plan. Step 1. Identify your most likely legal needs. Renter? Learn landlord-tenant law. Worker? Know employment rights. Driver? Understand traffic and accident law. Parent? Study family law basics. Step 2. Gather your legal documents. Find your leases, contracts, insurance policies. Organize them in one place. Note expiration dates and important terms. Step 3. Build your legal resources. Bookmark legal research sites. Save legal aid contact information. Identify a lawyer for consultations. Know where your local courthouse is. Step 4. Stay informed. Laws change. Follow legal news in your areas of concern. Update your knowledge annually. Review contracts before they renew. Remember I promised to share the single most important legal tip? Here it is. Document everything. The person with better documentation almost always wins. Written agreements beat verbal claims. Photos beat memories. Time-stamped records beat testimony. Email trails beat he said, she said. Start today. Save important texts and emails. Take photos of conditions and damages. Write notes after important conversations. Keep receipts for everything. This one habit will protect you more than anything else in this entire video. Congratulations! You now know more about the law than 95% of people. You understand how legal systems work, what your rights are, and how to protect yourself. This knowledge is power. You can negotiate contracts more effectively. You can recognize when you need legal help. You can protect yourself from exploitation. You can pursue justice when wronged. Remember, the law exists to serve you. It protects your rights, your property, and your freedom. But it only works if you know it and use it. Share this video with someone who needs this knowledge. And remember, document everything. That's the secret. Stay safe, stay informed, and take control of your legal life.